Hi everyone, and welcome to today's webinar on how can Australia's social security system improve the support it provides to people experiencing family and domestic violence. Before we get started, I'd like to acknowledge the traditional owners of the land on which we are holding this webinar today. In Brisbane, they are the Turrbal and Yagara people. I wish to pay my respects to their elders past, present and emerging, and acknowledge the important role Aboriginal and Torres Strait Islanders continue to play in our society. As this webinar is being viewed by people across Queensland and Australia, I'd like to also pay my respects to the traditional owners of the land throughout the country and extend a warm welcome to any First Australians listening today. This presentation and webinar is for professional development and education purposes for Community Legal Centre staff and is not intended to provide legal advice. It is not to be used for commercial purposes without the express permission of the author. Information is current as of the 2nd of April 2019. So today we are joined by Sally Cameron from the National Social Security Rights Network, who recently authored a report asking how well Australia's social security system supports victims of family and domestic violence. Sally will be talking to us about changes to social security law currently under consideration or being implemented as a result of recent research, as well as the various ways in which family and domestic violence impacts on a person's social security, from crisis payment to social security debts incurred as a result of coercion and duress. This information will help you better advocate for clients whose experiences of domestic violence should be taken into account by the social security system. Today's webinar is being recorded and we'll have the recording available to download later today or tomorrow. The PowerPoints and other materials have been emailed out to everyone who registered and are available to download from our website and from the handout section of the GoToWebinar control panel. You can ask questions either by typing your question into the question box on the control panel for me to read out to Sally, or pressing the button that looks like a hand so that we see a hand go up at our end and can unmute you so that you can ask your question via the microphone. I'll now hand over to Sally and talk to you again at the end of the session. Sally, thank you.
Thank you for that. Okay, so today's webinar, can I get rid of that? Here we go. Basically, I'm wondering if you can see, do I need to get rid of this panel on the right, or can you just see my PowerPoint?
Sally, everybody can just see your PowerPoint. You don't need to worry about that.
Okay, great. All right. Just try and shrink that down. I've just got something blocking my screen. Okay, so today I'm going to talk a bit about a report that the National Network did considering how well Australia's social security system is doing supporting victims of family and domestic violence. So as our starting point, wait, there we go. I'm just having trouble with the buttons. Yeah. If you can just give me one moment so I can shrink the dialog box so I can read my screen. I'm getting there. So first of all, we started by looking at trying to find a kind of universal definition of family and domestic violence that's used in Australia, and what's quickly apparent is that there isn't one, even though there are numerous official policies and documents dealing with the issue. But in general, we took as our definition that family and domestic violence includes conduct that's violent, threatening, coercive or controlling and intended to cause harm to someone in your family or household, causing them to be fearful. And that includes a current or former intimate partner. And taking the definition of family violence more broadly, then it extends obviously to other family members and persons in the same household. And in developing this, we did have some reference to, Australia's family and domestic violence strategy, which uses a definition which is quite broad, including co-tenants and people sharing housing, and also noting that Aboriginal and Torres Strait Islander people tend to use the definition of family violence because it more overtly encompasses broad kinship relationships. Oh, sorry, I'm going again. Here we go. So what did we know? Well, as our starting point, we looked at available research, and it's quite apparent that family and domestic violence, it is prevalent. It occurs across ages and socioeconomic and demographic groups. It predominantly affects women and children. And importantly, it's the most pervasive form of violence experienced by women, whereas men are more likely to experience violence from strangers and in a public place. So for women, this is where violence plays out. 1 in 6 Australian women and 1 in 16 men have been subjected to physical or sexual violence by a partner since they were 15 years of age. And then each year, almost 3,000 women and more than 500 men are hospitalised because of an assault by a spouse. So there's an enormous amount of violence of various kinds, but frequently it is serious enough to require hospitalisation. And then that last point is clear that approximately one woman is killed by an intimate partner each week and 1 man a month. All right, so I just want to talk very briefly about the methodology we use to come up with our findings. And the very first thing that we did was we appointed an advisory group who had a number of roles. So that included that they help steer the direction of the research. They were able to give input on very specific questions we had according to their areas of expertise. And then they were really useful helping us negotiate ethical considerations and issues of process. And then, of course, they provided commentary on the final report. So you can see there the list that it's people drawn from academic, legal and social practice in the range of relevant issues like human rights, obviously family and domestic violence, social security law, feminist legal theory, and homelessness. And you know, these things don't always go to plan, but I can testify to the really great input that we had from our advisory group and the value they provided. So to try and work out really how domestic and family violence intersect with social security law, we undertook a multi-stage process. The first thing we did was a quick scoping of NSSRN members to gauge the frequency, the importance, how impactful this is on people's casework. And then we decided that given the scale of the issue, we would focus our research on the work of Welfare Rights Centre in New South Wales. And just to do that, we went through the class system, which many of you will be familiar with, the software of recording cases, which turned out to be an extremely onerous process, because while we could immediately identify how many cases Welfare Rights Centre or any other community legal centre we had to go through laboriously and read every single case to find out who those people were. There was no possibility to just come up with a list of names, and that required the efforts of a really significant number of volunteers and interns who spent hours, weeks going through cases to come up with our case description. So I'd just like to acknowledge their work in bringing this all together. We also had the support of a couple of major legal firms who helped us do a review of AAT and federal court cases during the previous 2 years, and also a literature review of recent Australian and international research on this issue, because we wanted to basically cross-reference our findings against other work that was being done to ensure that we weren't off track, and also to see where we were finding things that hadn't so far been identified. We did a review of Centrelink and DHS resources, and lastly we did a survey of our members about their clients' experiences trying to resolve social security issues. And in that survey we asked them questions, I won't go through all of them, but we asked them questions like, how would you describe staff attitudes and willingness to help? does Centrelink have effective systems in place? Are people able to get access to social work? So really quite practical questions about clients' experiences dealing with Centrelink. And again, that was a really valuable exercise, because obviously people are extremely busy, don't necessarily think that their input is valuable, but the information we got through that, I don't know whether it was more useful to have people confirming what others said, or when people would, you know, we'd come across new issues as the process went along. But that collective knowledge, bringing it all together and putting it in one place, was really valuable. Okay, so to turn to the review of cases, that is the kind of substantive data that informs this piece of work. We looked at, there were 3,627 advices where a client had said that they had recently experienced domestic violence. So you may well know that every client contacting a community legal centre is to be asked the question, are you currently or have you recently experienced domestic violence? And an indicator is then put on their file if they reply yes. So of those, we drilled down to identify that during the, I have to do quick maths, 15-month period, there were 2,708 discrete clients, about 200 of whom said that they had recently or were experiencing family or domestic violence. And then because the when people are taking their notes initially, they weren't necessarily focused on this issue. There weren't always clear explanations of what was occurring. So we limited our analysis to the 93 cases where we had enough information on file to make an assessment about what had gone on. What we found, I think here no surprise, is that the vast majority of family and domestic violence is by men against their intimate partner or ex-partner, but also that, you know, family violence, elder abuse, it's a wide net, and there is violence affecting various people in various kinds of relationships, family and household relationships. We also found that it just was across all payment types. So I think we started this with a bit of a preconception that it would be more apparent with particular payment types, and I guess it is somewhat more apparent with some. You can see the table there, the chart there, but it really, this issue is cutting across all payment types. And then we looked at what the issues were. So not really a surprise, the most common issue is about people being a member of a couple or not. And then there were issues around residency, income test, dependency of children, and you can see the list there. And just noting that sometimes more than one of those factors was an issue in the case. But that meant, because of the structure of Social Security law, that we needed to look at how this issue is addressed across lots and lots of different sections. So the key points that we found in relation to Social Security and its intersection with family and domestic violence were these. The first is that the system obviously has a preconception that couples share their income, which some do, but many don't. There is the ongoing issue of incorrect information causing a victim to accrue a debt. Sometimes that information may have been given intentionally, but often it's not, it hasn't been. The fear of being caught out by Centrelink reduces people's capacity to leave. So that might be that they've made a mistake and then realised that there's some kind of mistake, or they've intentionally provided, you know, information that wasn't bang on, and that is leveraged by a violent partner to keep them in the household and used as a way to control them. There's the issue that social security income is too low to secure safe accommodation, so people trying to get out of a violent household are just unable to leave because they cannot save and cannot get the money that's required to start that process. And this ongoing issue that establishing social security entitlement becomes too difficult. People give up because the paperwork is just too onerous and the process of interacting with Centrelink staff is just too difficult. So when we looked at what are the issues, so we also thought that a major issue would be debt, and it was, but probably not to the extent that we had imagined. So almost 40% of cases involved a person having accrued a debt, and that was because a whole range of reasons, but things like people not disclosing they're in a marriage, they're a member of a couple, and so they've received payment even though they're ineligible, or perhaps they've been paid at the wrong rate. And the reasons for not disclosing were varied, including, threats from a partner. So also they hadn't disclosed their partner's income, sometimes because they're not aware of that income or because they've been pushed or coerced into providing false information. They hadn't disclosed reduced care of children, and again, that was often because the care of children was unclear or unclear in terms of the department's rules, but also unclear to the parents about where children would be on any given day, and so having to frequently re-report and change arrangements just got beyond people. And some people incurred a debt because they had received, after a very, very long wait, they had received arrears of child support, which is a real bummer. If you've waited that long to get, your entitlement, finally get a big lump sum of child support and then get a letter from Centrelink saying that you have to pay back thousands of dollars in family payments. The other thing which we hadn't expected was just the really high proportion of homelessness. So obviously this issue intersects, but 60% of the clients whose cases we looked at were either homeless, had become homeless, or at risk of homelessness. And so people were living with friends or in one of their children's homes. They were people were about to be evicted because they didn't have money to pay the rent. They'd been kicked out of home by a partner, people living in cars. There were people who'd been separated for some time, but they just could not manage to re-establish housing security. And then there were the people who were facing homelessness, but they hadn't left the violent household because they were unable to get social security, and also a couple of people who were unable to access the refuge system or community housing because of the requirement to pay rent and some kind of disassociation between that support system and Centrelink, and people being able to work out what they needed to do first. The situation was particularly dire for women from New Zealand, which I will talk about in a moment, but that came up a number of times. Okay, so just quickly to review this issue, core to Australian social security, the system is that you are a member of a couple or you are not a member of a couple, and there is the presumption that if you are a member of couple, you will conduct your relationship according to a set of preconceived ideas. So the cases that we came across included cases where a partner refused to share their income with a partner and dependent child or children. So the two people were living together, but in fact the woman had absolutely no way to access any funds at all, even though half of the money at least was being paid in her name. There were cases of the partner stealing, using the key card or various other methods to just steal their female partner's money, withholding information about income or assets, making it impossible for the female partner to inform Centrelink of their income. Cases of intimidation and physical violence, including like really severe violence, including things like, you know, choking and things like that, forcing a woman to either not declare income, not declare their or their partner's income, and delaying tax returns, which is a classic way to delay child support payments. So the other key points I wanted to go through, other than the issue of member of a couple. Oh, I should just say, member of a couple, I presume people know, but you may not, that there are a number of ways that Centrelink can consider whether, even living in the same house, you're actually a member of a couple or not. And so that is one of the areas that we wanted to make recommendations in this area, which I'll talk about in a second. So other than the issue of whether a person's a member of a couple, there were other issues like compensation preclusion periods. So that issue makes it really apparent that these issues of family and domestic violence really they continue post-separation. So, for example, there was one woman who'd received a very sizable compensation payment that precluded her from Social Security income for about 11 years. But just a few years after she was paid, she got married, had a number of children. The partner was violent for years and becoming increasingly violent as the relationship went on, which Centrelink was fully aware of. Now, when the woman got her payment initially, she'd used half the money to buy a modest house, a modest car, and pay her legal fees with a plan to live off the funds for the full period. And she had done that. So she'd almost reached the end of the preclusion period when her husband insisted that she hand over $80,000 so he could buy a business to support them financially. When the violence became so extreme that she just couldn't live there anymore and managed to leave, he then refused to repay the money or provide any financial support for her or the children. As I mentioned, numerous social workers, including a Centrelink social worker, were well aware of the violence. However, they refused to apply special circumstances and allow her to access Social Security 2 years before the end of the preclusion period, despite having a $20,000 debt and living off charity. So, yes, one of our recommendations was for family and domestic violence to be considered, to be named as an issue to be considered whether compensation preclusion periods can be waived. So another related issue was around debt waiver special circumstances. So if a person has accrued a debt, unknowingly, having not made false statements, then that debt can be waived in special circumstances. But there were numerous cases where, despite there being a number of different circumstances that had applied to an individual, including domestic violence, which had contributed to the debt, Centrelink had refused to waive the debt. And that's another area in which we were seeking to have family and domestic violence named as an issue that must be considered when special circumstances are being considered. The next area was around crisis payment, which is probably no surprise because the payment is designed to be used when people find themselves in a crisis, such as family or domestic violence, which results in one party leaving the family home. So we had a number of recommendations around crisis payment. So just to be clear, you know, Centrelink is doing a much better job than it was doing years ago in that they are making payments. They're making crisis payments around this issue. There was, I think, 17,000 payments made in the previous financial year, but there are still these issues that mean that that there are people who are most vulnerable who don't access it. So one of them is it has a nexus with a home. So someone has to leave the family home, and there have been cases where just really foolish decisions being made, like the partner's gone to jail as a consequence of his actions with the family and domestic violence, and someone in Centrelink has decided that he hasn't permanently left the family home because he will get out of jail and may return to the family home. So we recommended that the nexus with home be removed. There is a requirement for a claim to be made within 7 days of the circumstances occurring. We have asked for that to be extended to at least 14 days. We've asked for greater clarity on the DHS website, making it very clear that a claim must be put in within 7 days or it will not be considered. And then we were ambitious. We asked for crisis payment to be extended to women in financial hardship who weren't otherwise eligible for Social Security, and we asked for the amount of money to be raised. So at the moment it is equivalent to a single week's payment. We asked that to be raised to 4 weeks, and we asked for the payment to be extended up to 6 times a year. At the moment, it is only payable 4 times a year, which is frustrating and actually is adequate for many women and other people who need to access it. But for those people who are particularly vulnerable, it is only available 4 times. And as one of the DHS social workers said to us when we met with them, given that there's research showing that often someone has to try to leave 6 or 7 times before they are able to leave the home, we would like that payment extended to 6 times a year if necessary. Okay, the newly arrived residents waiting period, I'll just speak very briefly about that. So that's obviously a disaster for many people. It's now up to 4 years for working age payments and special benefit. People must wait 4 years to be eligible for Social Security payments, or 2 years for family payment. So there were numerous cases of women who had come to Australia either with a partner or started a relationship with an Australian resident who then were trapped in the household with a violent partner because they were unable to access any Social Security payment, but were responsible for often for the care of young children. And the situation is particularly bad again for women from New Zealand who come under a slightly different mechanism, but who are also subject to a waiting period that just locks them out of Social Security, so they can't leave the home. Care of children obviously complicates things, so there was complexity around trying to get a violent partner or ex-partner to sign paperwork, trying to establish where the child is on any week, and we've made recommendations on that. And the child support exemption. So it is possible to get an exemption from seeking child support if the former partner is violent. However, that requires the woman to be referred to a social worker or to make it known to Centrelink that there is a real issue. And if they don't pursue the exemption, they can end up with a family payment debt. Okay, and I'll whiz through this list. So we also, as I said earlier, we reviewed our members and looked at the case notes around how people find their interactions with Centrelink. So training of staff is obviously an issue. So, you know, people walk in, they rock up at the counter. You might encounter the most flexible, open-minded, supportive, encouraging staff member who has a very good understanding of Social Security law and policy, or you can, encounter some ning-nong who is obtuse, is acting as a gatekeeper, who is just not interested. So training is vital in that all Centrelink staff, that all of the tens of thousands of Centrelink staff understand the bottom line, that there is a bottom line that must not be crossed in relation to this issue. People identified the lack of safe spaces for disclosure, how disconcerting it is to walk into a Centrelink office and be expected to just say to someone, hello, I would like to talk about someone because of, the violence. And one woman summed it up really well when she said it was like walking into a post office and being expected to disclose your greatest secrets. There's clearly opportunities for staff to be more proactive, recognising people are in distress and asking questions and supporting them, and opportunities for staff to be more responsive, not acting as gatekeepers and trying to lock people out and identifying them as problematic and not letting them in. And also the issue of wait times, people experiencing real distress because of the wait times getting their claims processed. There's the impact of administrative requirements, so it just drives people to despair, the amount of paperwork that is required and the delays, and then at the same time receiving correspondence from Centrelink they can't understand. The reliance on information and communication technologies had a really big impact, obviously trying to be helpful in making information and services more available in regional and rural areas. But what it has done in this issue is meant that face-to-face support is often not available. And that includes the next point, access to social workers. So people didn't always find that talking to a social worker on the phone was the same as speaking to someone in person, and because of that inability to get some kind of therapeutic or empathetic relationship, they really didn't know whether they were being heard and didn't know whether to trust whether the services were all that they should be. And we also made some observations about administrative arrangements generally and centralising and formalising monitoring and expertise. So when NSSRN talks to DHS and DSS, that has traditionally been that those two departments are spoken to separately at their request, and so we wanted assurance that they had internal mechanisms, they had designated people responsible in this area, and that they were speaking to each other about these issues. So just before I go on to the next area, I want to just say it is not possible to overstate the frustration and distress of these mainly women who were trying to extricate themselves from family and domestic violence and who just felt their experience in dealing with Centrelink was the last straw. So rather than a theoretical issue, it had a major impact, including numerous clients referring to suicide or to harming themselves because they just couldn't make it through the system. Okay, so what have we achieved? Well, we had a long list. Oh, I've got them numbered. I'll just check. How many were there? There were, I think there were 24 or so recommendations that we sought. And I can honestly say that the two departments, DHS and DSS, have really been more supportive than really we probably would have expected. So there is real engagement around this issue in terms of the departments. I won't say it's perfect, but there has been a genuine interest and will to make some changes. So we have seen some changes. They have generally related to the guide to Social Security law rather than legislation, partly because of, we think, where we are in the election cycle, and also because at a departmental level it's obviously quicker and easier to get changes through. So the very first change, which I don't know, this is kind of ridiculous. When we started this, I looked at the guide or the Act to try and find what the definition of family and or domestic violence was, and peculiarly the only definition related only to crisis payment. So that's no doubt just a remnant of when they brought in crisis payment domestic violence was considered crucial to it, but we wanted the definition, we wanted it to have a clear definition across the whole Act, because as you know, I said before, it's vital that whoever in Centrelink opens the page can see that, yes, this must be applied across all payments. And so that definition has now been changed. The definition is the same, but it applies across every section, basically, of the Act, across all payment types. So that has been a win. The next one, which we're really pleased with, is that they now name domestic violence as a consideration when they're working out whether they will waive a compensation preclusion period due to special circumstances. So that has also been a win. And they have two other things we saw. They have named that domestic violence may indicate that two people living together may not be a member of a couple, because in the past it has possibly been used for that reason, but it has also been used to argue that people are a member of a couple. So we've now named that if there's domestic violence, Centrelink has to have a closer look at whether people are a member of a couple or not. And related, that domestic violence may indicate that two people are living together under one roof, which then may affect whether they are eligible for payment and their rate of payment. So in a short amount of time, we've had changes, which is really very satisfying. Then on the 20th of March, we had another change which relates to the ability to claim crisis payment and the rule that it must be claimed within 7 days. Leanne, I don't know, would you like to speak to this one and to the two different circumstances in which a claim may not need to be made within 7 days? It may be extended to 14 days.
Just unmuted myself, so I hope everyone can hear me.
Yep.
Great. So when we initially asked for the claim period to be extended from 7 to 14 days, we had been envisaging that would be a change to legislation. And as Sally has explained, that is a more difficult process, particularly where we are in the election cycle. And because DSS and DHS have been so engaged with trying to implement some of these key priority recommendations working with us, they've kind of developed this workaround that enables them to extend the claim period without changing the legislation. So to explain this fully, I need to explain what used to be called intent to claim. So there was this provision in the Social Security law where a person could just contact Centrelink and their first contact would be regarded as the date on which they claimed a payment, even if it took them some days or weeks after that to pull together everything they needed to formally make the claim. Unfortunately, that law changed last year and the intent to claim was basically abolished. However, due to advocacy from us and other organisations about people in difficult circumstances who are particularly vulnerable, there were some vulnerable groups and discretion built into that abolishment of intent to claim. And DSS, in changing the guide around the issue of domestic and family violence, has used that discretion to change the guide so that someone who is claiming crisis payment can comply with the current legislative requirement of claiming within 7 days. If they contact Centrelink within that 7-day period, but then they can have an additional 14 days from the date of that contact in order to get all their documents and other evidence required to make the full claim. What we were finding through the research was that different people would encounter Centrelink depending on who they ended up talking to when they spoke to Centrelink, would have a more sympathetic person who would understand their situation and exercise that discretion in a more compassionate way and provide what was in essence an extension through an intent to claim kind of discretion. And others were finding that they were talking to someone at Centrelink who was really hardline and saying, no, you've just got 7 days and that's over and it's too late to claim. So what we're asking for in a change to the guide was just to make it really clear that there would be another 14 days after the initial contact with Centrelink. So for anyone advocating for clients or assisting clients who have experienced domestic violence and are trying to claim crisis payment, they can point to these parts of the guide that we've got here in the PowerPoint, 3.7.4.20 and 3.7.4.25, to argue that that period of being able to claim crisis payment should now be longer.
Thanks, Leanne. Yep. Okay, so there are the changes we have managed so far. Our priorities moving forward, whoops, here we go. We're seeking an amendment to the guide to clarify that a history of family and domestic violence should be considered as special circumstances in relation to debt waiver. So as I said, it's now been named in terms of compensation preclusion period, but it hasn't been named as a consideration in terms of waiving a debt. And particularly, we would like it named in terms of something to be considered before a case is referred to the Director of Public Prosecutions, because we had clear examples of cases where women had accrued a debt as a result of being forced by a partner to give false information, but also because of a whole range of circumstances around family and domestic violence, and they faced prosecution. So we didn't think we could get it up to say those cases should never be referred to DPP. That would be ideal, but we wanted it to be at least considered in terms of, you know, issues like intent and those kind of general criminal law principles. So we're still pushing for that. We're also pushing for the claim date to be extended instead of the rigmarole that Leanne has just had to explain, that simply they extend the claim period from 7 to 14 days, because we had clear cases where people had sought to, either they were unaware of crisis payment in the chaos that's surrounded the few days of leaving the family home, or the amount of paperwork was so immense that they spent longer than 7 days getting the paperwork together and then submitted it. So to simplify it, we'd like that extended. And as I said, we want it payable up to 6 times per year. The other thing that we've pushed, and there has been some engagement around this idea, was for expert positions in DSS and Department of Human Services. Not for, they panicked, so we're not saying we want those positions for clients to be able to ring the head of policy. It's more that if we are seeing a systematic issue that we have a direct contact to someone who has responsibility in this area, and as I said, we want an assurance they are speaking to their counterpart in the other department, but also the idea of a domestic violence hotline so that those calls can go through to staff who have some higher level of training around the way that violence may be impacting the client and the claim. And the other thing that really is urgent is to remove the newly arrived residents waiting period for people escaping domestic violence relationships so they can access special benefit. So, you know, we've had a precedent of something like that occurring years ago in terms of immigration. If someone was here on a visa which was dependent on their relationship with their spouse, and then domestic violence was identified in the relationship, that they would be able to remain in Australia. So we've seen it happen before, just outside Social Security. So I don't think it's impossible. It's obviously a big ask because there's money attached, and they're resisting, but that's something we would like to push for. But particularly the absurdity around people from New Zealand who come here under completely different visa conditions, so they're not actually prompted to go through the steps that get them Australian residence and Australian citizenship. So then at a time of crisis, regardless of how long they've been here, paid tax, superannuation, all those things, they are just locked out of Social Security entitlement. So yes, there are priority issues moving forward. I won't go through the full list of recommendations. Leanne, can I just ask whether there's anything else you'd particularly like to add, or otherwise we can open it up to questions?
The only thing I would add is that we're looking at doing an evaluation down the line of the impact of having these changes to the guide. So if anyone does come across clients in these situations moving forward, it'd be great to hear from you if having these changes, making it clear to people working at Centrelink that domestic violence should be taken into consideration and properly considered, if that's made any difference to your clients.
Thank you for that. The other thing I just was going to mention was that Social Security Rights Victoria is engaged in a longer term project that's not research per se, but they're really looking around these issues and the way that services can respond. So that's an ongoing process people can possibly feed into. So I guess we're at the point, I'm wondering whether anyone has any particular questions.
Thank you so much, Sally and Leanne. It was really great to hear about your research and your observations and recommendations and the changes that have been made as a result. So everybody listening, feel free to type your questions into the question box. We already had one in advance from Helen at Caxton. She's asking if the changes underway will help to address elder abuse, for example, abusive family members who are receiving carer payments but not giving care.
I think the changes very generally extend to carer abuse, but partly because the definition of family and domestic violence in the Social Security Act is broad enough to cover those relationships. So I'd say yes, they will. Are there any other questions?
All right, we haven't had any more questions. So, yeah, unless nothing's popping up. So, it seems like you've covered everything already in your presentation, which is really great.
Great.
Thank you so much.
Thank you.
This will be available online, the slides as well as the recording, so people can watch it in the future.
Thank you very much, everybody.
That's it. All right. I wonder if I should